discussion, I will be able to tackle about inadequacy of wages as well as the methods of settling industrial disputes. First, let us know what is inadequacy of wages. Means it is low wages produce effects which are harmful and undesirable, not only for the workers themselves but also for the employers and society. In fact, most of the bad effects of unemployment make themselves felt through curtailment of income. Inadequate wages are often the result of part-time and irregular employment. Take note that wages are very different from salary, since it depends on your time of hours work, while salary stands as the total or the whole of your contract as you do as your certain job.
But as we experience this matter, there will be settling industrial disputes happen. And industrial disputes as a conflict or a difference in opinion between management and workers regarding employment. It is a disagreement between an employer and employees, representatives such as trade union, and the issue of disagreement is usually pay or other working conditions.
However, there are methods used for preventing and settling industrial disputes. A dispute, therefore, needs to be settled as early as possible. Various methods are available for resolving disputes. More important of them are, first will be the collective bargaining. It's probably the most effective method of resolving industrial disputes. It occurs when the representatives of a labor union meet management representatives to determine employees' wages and benefits, to create or revise work rules, or to resolve disputes as well as the violation of the labor contract. Collective bargaining, both employees as well as employers benefits. This means that the basic interests of the management are protected and also the rights of the employees. The two sides have a responsibility towards each other. Second will be the code discipline. Defines duties and responsibilities of employers and workers. The objectives of the code are to ensure that employees and employers recognize each other's rights and obligations, and to promote constructive cooperation between the parties concerned all the levels, and also to secure settlement of dispute and grievances by negotiation, conciliation, and voluntary arbitration, where will be tackled next. And to eliminate all forms of coercion, intimidation, and violence in industrial relations, to avoid work stoppages, and to facilitate the free growth of trade unions, and lastly, to maintain discipline in industry. The third will be the grievance procedure. Is another method of resolving disputes. All labor agreements contain some form of grievance procedure. And if the procedure is followed strictly, probably any dispute can easily be resolved. In the meanwhile, a grievance may be understood as an employee's dissatisfaction or feeling of personal injustice relating to his or her employment relationship. Other conditions which may rise to a grievance are the violation of law, the violation of the extent of the parties as stipulated during contract negotiations, the violation of company rules, a change in working conditions or past company practices, as well as a violation of health and or safety standards. The grievance needs to be resolved according to a set procedure. The next method will be the arbitration. Arbitration is a procedure in which a neutral third party studies the bargaining situation, listens to both the parties and gathers information, and then makes recommendations that are binding on the parties, which is effective as a means of resolving disputes because it is established by the parties themselves and the decision is acceptable to them and relatively expeditious when compared to courts and tribunals. Delays are cut down and settlements are speed up. Next method will be the conciliation, which is a process by which representatives of workers and employees are brought together before a third party with a view to persuade them to arrive at an agreement by mutual discussion between them. The third party may be one individual or a group of people, and the alternative name for the third party as mediator. In addition, it may be stated that the conciliator has no power to force a settlement, but work with the parties separately to determine their respective positions, explain oppositions more fully to the oppositions, point out bases for agreement that may not have been apparent previously, helps in the search for solutions, and generally facilitates the reach of an agreement. Next method will be the adjudication, means a mandatory settlement of an industrial dispute by a labor court or a tribunal. Generally, the government refers a dispute or adjudication depending on the failure of conciliation proceedings, since the conciliation or the conciliator has no power, but there will be the chance to settle the both parties. According to Section 10 of the Industrial Disputes Act 1947, provide for reference of a dispute to labor court or tribunal. The Act also lays down the rules regarding the composition, and disputes are generally referred to adjudication in the recommendation of the conciliation officer who had dealt with them earlier. However, the government has discretionary powers to accept or reject recommendation of the conciliation officer. It is obvious that once a dispute is referred to adjudication, the verdict of a labor court or tribunal is binding on both the parties. The system of adjudication is the most significant instrument of resolving disputes, but it has been criticized because of the delay involved in resolving conflicts. Continued dependence on adjudication deprives the trade unions of the right to recognize the considerate their strength. And the last method to use will be the consultative machinery. Towards the end, it is essential to refer the consultative machinery set by the government to resolve the disagreement or the conflicts between the parties. The main function of consultative machinery is to bring the spirit of cooperation and goodwill. A consultative machinery operates at the plant, industry, state, and the national levels. At the plant level, there are work committees and joint management councils. Being essentially bipartite in character, works committees are constituted as per the provisions of the Industrial Disputes Act 1947 powers of labor courts and tribunals. So, all the methods take process and it will be happen in the Court of Appeal.
So that's all of my topic. I hope you will learn something new. Thank you for watching.